I'm here with Kathleen from Patient Care Rights Litigation Project. She is a real freedom fighter, actually goes into the court system and does the fighting a lot of people won't do. Tell us what you're doing this year, Kathleen.
Currently on right now in the courts, the PCRLP has 3 lawsuits pending. One is an amicus brief in Coates versus Dish Network. This will have national precedent. The ruling, it's in the Colorado Supreme Court. It's on a case over a quadriplegic who worked for Dish Network, and he lost his job for failing a urinalysis test 3 years after he had done good work performance. It was just a random test. When he was fired from Dish for the bad hot piss test, he applied to the state of Colorado for an unemployment check, and the state of Colorado denied him an unemployment check, saying that he was lawfully fired for his illegal cannabis use, even though he was a state-registered medical marijuana patient in the state of Colorado.
That's a problem right there.
That's a problem. Then he appealed it to the Colorado Court of Appeals. Colorado Court of Appeals has ruled that cannabis is illegal under both state and federal law. That's very problematic. So the PCRLP, Patient Caregiver Rights Litigation Project's brief, we argue that Colorado voters legalized medical cannabis in 2000, and that patients actually have rights and not privileges that can be taken away. That's what our brief argues. Our brief also argues that cannabis is not lawfully placed on the Controlled Substance Act schedule at all. The Controlled Substances Act is a rule, and it has all different rules inside of it. And it says that in order for the federal government to place any substance on the schedule, anywhere on the schedule, that the feds have 1 year with a one-time only 6-month extension to prove the substance they're placing meets all the requirements of that schedule. Schedule 1 means
highly
addictive and no known medical use. This was back in 1971. So at the time, the feds created the schedule, they gave the list to Congress, and Congress actually wrote back to the Fed, the DEA, and said, we agree with everything on Schedule 1 except marijuana. We're going to give it a temporary placement on the Controlled Substances Act, and under the Controlled Substances Act itself, a temporary placement, once again, 1 year, one time only 6-month extension. And Congress said, the Schaefer Commission is already working on this research. So the feds had a year and with a 6-month extension to prove that cannabis both was harmful and highly addictive. And what ended up happening is the Schaefer Commission's findings were that cannabis was so safe it didn't need to be on schedule. Nixon shredded the research and began heavy-duty the war on cannabis users, actually, not cannabis, on users. And so our brief also argues that the feds have been marching around for the last 40-some years and unlawfully claiming that they get to prosecute people for cannabis under the Controlled Substances Act, when under the Controlled Substances Act itself, they haven't even met the obligations of that act to place it, let alone Schedule 1 anywhere on the schedule at all.
And so you're saying for 70 years they've been operating under this, having it on Schedule 1 when they only had a 6-month window or 1.5 years?
It was 1 year with a one-time only 6-month extension to prove to we the people that substance meets, it's not just cannabis, it's any substance they put on schedule.
Sure.
Which I don't believe they've actually proven LSD is highly addictive, or psilocybin either. They refuse to acknowledge that either of those substances have medicinal value. We know now with research that actually LSD and psilocybin help people get over PTSD and suicidal thoughts. I think there was a study last year that showed that seniors who were given LSD once were 15% decrease in suicide because these seniors woke up now having a reason to live. So it's not just cannabis that is actually in question here, but in our brief we're addressing cannabis. But people don't know that the Controlled Substances Act requires the feds to prove to all of us why something is on the schedule, and it has to meet all the requirements of the schedule they place it on. So I don't believe they've done that at all. We know they haven't with cannabis. I also think it addresses other substances in Schedule 1.
A complete affront to anyone with intelligence. If heroin's on Schedule 1, cocaine's on Schedule 2, anabolic steroids are on Schedule 3, why is cannabis not on Schedule 4?
And alcohol and tobacco are not on schedule.
At all.
The most deadly substances known to man, both of them, alcohol and tobacco, are exempt from the Controlled Substances
Well, we
Act.
can see what lobbying gets you and what...
Yes, we sure can.